So this is a really good question. I get this question quite often. And most people think that child support ends at 18. But in fact, the age of emancipation in New York is 21. And it's kind of funky because custody, courts don't have any jurisdiction over children over the age of 18 for custody purposes, but child support extends to the age of 21. Now, are there instances where a child could emancipate for child support purposes before the age of 21? Absolutely. Some of those occurrences would be if the child is entering into the military, if they're married, they become married, perhaps the child has completed 4 years of a college education, they've graduated, they have a degree, now they're considered self-supporting. There are cases where children just leave the home of their parents. And to make the argument that your child is emancipated for child support purposes in that event, you wouldn't be able to make the argument if the child had left for, if there were issues with neglect or abuse. But if they left for some other reason, and it was a good reason, they would likely be considered emancipated. So certainly, we could go on. People come to agreements with regard to how and why their children would become emancipated as far as their divorce agreements and their support agreements. You can get creative. There are few cases where support would actually be extended beyond the age of 21. And that really has to do with if you have a handicapped or disabled child, or if you have a divorce decree and you and your spouse, your ex-spouse now, have actually agreed to extend support in certain circumstances. So every case is different, every child is different. I would strongly encourage you to take the facts of your case, the situation that you're in, and bring it to an experienced attorney that deals with family law issues such as this, support issues, to really get a good idea of where you want to go with your case and really what you're entitled to.